And we'll go on to our next item, Senate Bill 1389. I feel like my co-chair does as much work on this committee as I do because I have bills, so I'm going to hand those over to her. And with that, I'll go down and take the podium.
Committee, we now have before us Senate Bill 1389. Senator McKenzie.
Thank you, Senator Lodge and committee. I appreciate the patience of the committee members on this. We had a previous version of this bill that we printed, and then we did additional work on that when we realized that it had consequences that we hadn't intended. That was pointed out by a number of citizens who I appreciate for helping us get a better bill, and I think we have much wider support because of that. This bill as well is done as an amendment language rather than just a cut and replace, so you can more clearly see what it does. The significant change starts on page 2. Currently under Idaho law, as far back as I can tell that we've ever had as a state, we've had permitless carry outside city limits. And then within city limits, there was a restriction, I believe it was put in 1909. I don't know. It's as far back as I could trace that. So we've had this disconnect between cities and counties. And we're, as a state, we're a little different than a lot of states. We allow basically anybody can incorporate and create a city. And so in Idaho, we have cities that have been as small as 5 or 6 people, all up to major metropolitan areas. But for some reason, we've had the disconnect between the counties and the cities. And so what this would do, basically provide on the list of those who could carry concealed without a permit would now include those who are over the age of 21, resident of Idaho, and are not disqualified from getting a license under subsection 11, which I'll discuss previously. The current language that refers to outside the limits of a city stays there, but we make sure that it's qualified so that it's a person over the age of 18 and is not otherwise disqualified from being issued a license under section 11. So that what that does is it preserves the right of someone who currently had the right to carry outside city limits, who was 18 and over, so long as they're not disqualified under section 11. And section 11, which starts on page 4, is the list of reasons why you couldn't be issued a license under Idaho law. It includes things like being charged with a crime, fugitive from law, under the influence of drugs. Those are the current things. This bill amends the language with respect to withheld judgment or suspended sentence, because as you read the current language, I don't think it was clear or quite tracked how these actually occurred. Under current language, it just says if you get a withheld judgment, if 3 years elapse since entry of judgment or successful completion of probation, then you could get a license. But 3 years, you could still be on probation for a lot of things. If you're getting a felony, it's likely you're going to have probation for longer than that. So the 3 years didn't make any sense. And as well, sometimes you get a withheld judgment, you finish probation, but then you don't go back and file the motion to get the withheld judgment dismissed, because you have to go back and do another motion. So this says if you get a suspended sentence or withheld judgment, you successfully complete probation, then after that period you could apply for a license. But that's limited by that long list of felonies under 18-310 that you can't get your license back for regardless. And that's a pretty significant list of serious crimes that we have in law. And then below that we added section I, which applies to misdemeanors. Previously in code, it just referred to violent misdemeanor, but it didn't define what that was. So this says if you receive a period of probation after being adjudicated guilty of or received a withheld judgment for, and the reason it says period of probation there is that it's conceivable you could, if a judge thinks it's a minor violation, they may just give you a fine and not put you on probation. In that case, this wouldn't apply. But if you get a period of probation, whether it's you're adjudicated guilty or you get a withheld judgment, and it's for a crime of violence, which I just used the federal definition, which is intentional use, attempted use, or threatened use of physical force. And that's just from federal code, although I added the word intentional before that to clarify that it's not just coincidental use of those. Then you won't get your gun rights back until you successfully complete probation. And I think it clarifies the language that we had before, which wasn't, I don't think, very clear. And then the other change that this makes is on page 7 with regard to those who are 18 to 21 years old, that it provides that if they want to get a permit at that age, that they'll go through the same process that you would go to get an enhanced carry permit. So at that younger age, they have to go through a training requirement. But the benefit of that is not just the training, but also the fact that once they turn 21, this provides they just basically automatically qualify for the enhanced license because they've already gone through that. So we hope that is an incentive for people to go through the training. And then on page 8, prohibited conduct, because we added subsection 4F under 183302, we added that to the list of there where you couldn't conceal within a courthouse, juvenile detention facility, jail, public or private school as under current code. But we made an exception to those, so if it's exceptions for police officers within the scope of their employment, security personnel while engaged in their employment, or a person who's authorized to carry a weapon by a person, board, or other entity having authority over the building or facility. I think everyone assumed that those would be implied, but by the language of the code, they weren't specifically provided for. So that's what that does. So that's what the bill does. I think it's more than anything else. It's a policy issue as to how we want to handle this within the state. And so I'd be open for questions, and I think there's quite a few people who signed up to testify as well.
Committee, are there any questions for Senator McKenzie? Senator Stennett.
Thank you, Madam Chairman. Good morning, Chairman. So I'm just trying to understand what this does. So you have no background checks and no safety training that's required to concealed carry in this. Is that correct?
Senator McKenzie.
Right. Consistent with concealed carry, we've always had outside city limits.
Follow up.
Senator Stennett.
Thank you. The little bit that I'm confused about is that if you're 18, you can carry outside of the city limits, but not inside. And if you're 21, you can carry in cities, but only if you're a resident of Idaho. That is a bit confusing to me.
Senator McKenzie.
Right. So under current law, those who are 18 to 21 can carry outside the city limits. If they want to conceal carry within city limits, then they've got to get the license and go through the training. That's consistent with what when we put in the enhanced carry license, it's basically the same standard that they would go through.
One more,
Bennett?
if I may. Thank you. So those 18 to 21 don't need to be residents of Idaho?
Senator McKenzie.
Thank you, Senator Lodge and Senator Stennett. To get that license issued, you would have to be a resident of Idaho as well.
Thank you.
Any further questions?
Madam Chair. Madam Chair, Mr. Chairman, I'm on page 5 where you inserted the word intentional. My question is, this is after the judgment is rendered. Does Does the ruling from the court state whether the use was intentional or not? And if not, who's going to determine whether it was intentional?
Senator McKenzie?
Thank you, Senator Lodge and Senator Hill. The information or complaint would typically have that. The reason I put intentional in there is because people could say drunk driving is a crime of violence because people can crash their cars. Drug possession is a crime of violence because communities where there's drug use have more violent crimes. This was an intent to limit it to those things that we think of as violent crimes, like battery, assault, and those kind of things, where it's the intentional use of the force that makes it the crime.
Madam Chair, follow up if I might.
Senator Hill?
Mr. Chairman, so you think it's going to be pretty plainly understood. I mean, you attorneys have been telling me for a long time how difficult it is to prove intent. And here we don't even have a court of law to determine it because the ruling has already been issued, and yet some issuer here has to judge the intent of someone. But if you think it's pretty clear, I will defer to you on that, but I just want you to tell me that.
Senator McKenzie?
Thank you, Senator Lodge and Senator Hill. I think it's clearer than what was in there. Under the current statute, it just said violent crime, and I didn't know what that meant. And so that's why I looked to the federal statute and found those elements, and I thought it should be, along with that, the intentional use. You shouldn't be, an accidental use of force, like if you're negligent, if you run into somebody with your car because you're not paying attention. So, I think over time it's clearer than what we had. Whether we still need to adjudicate it, that's potentially the case. Yeah.
Senator Lakey?
Thank you, Madam Chairman and Mr. Chairman. Just kind of a follow-up on those lines. As I read that, it's a misdemeanor offense that has an element, the intentional use. So doesn't the misdemeanor offense in its definition have a requirement for intent? So that would already be specified as to the type of misdemeanor we're talking about.
Senator McKenzie?
Yeah, Senator Lodge and Senator Lakey, that's true. And as well, even if it's just charged by citation, the jury instructions for those are going to have that as an element specified.
Are there any further questions for Senator McKenzie? Senator Stennett?
Thank you. It brought up from what Senator Hill said. Violent crime seems a lot more specific than intentional. So I guess you've said that violent crime was in there before, but it didn't seem clear to you. And I just think of intentional as being vaguer. Can you explain why you think that's more precise?
Senator McKenzie?
Well, just like the example I gave, if you have say negligent homicide, that's a very violent incident that's created, but it wasn't intentional. If you are, there's different crimes where you're basically negligent in what you do, but there's a violent result. This just limits it to where you are intentionally causing it. So the prime examples I can think of are battery or assault, which is the threat to use battery on someone, but both of those are intentional. And a lot of it's in the Idaho criminal jury instructions will define those that have it. And so we could try and do a litany of offenses that fit under that. I think it makes the code unnecessarily lengthy and wordy, but I think this is a better way to do it.
Follow up?
Senator Stennett?
But isn't it still considered almost as criminal if somebody unintentionally, in a passion or a fit, who uses a firearm that inherently kills somebody? Isn't that, even though that is unintentional, it still is grave?
Senator McKenzie?
Thank you, Senator. Well, if you intend to fire the gun, and being intoxicated is not a defense to that intent. It's a violent crime. If you unintentionally point a gun towards someone, that's a misdemeanor. So we distinguish between those two under the law right now.
Thank you.
Senator Winder?
Thank you, Madam Chairman. Just a couple of quick questions, just for the record, so we have it here. Tell me a little bit about what this does or does not do with reciprocity for other states.
Senator McKenzie?
So Dakota Moore can go into this a little further because he's dealing with other states, but as I understand, it doesn't affect reciprocity in any way. I think the only question that's come up on this is for the state of Washington's in their Attorney General's office given an opinion that if there are states that don't require a permit at all, then those states they don't have equivalent laws with regard to carry, and so they're not going to have reciprocity. And so that's not the case with this. We pretty carefully limit it to within city limits. You have to be over 21, and that's also the reason we put a resident of Idaho. So it's not just permitless carry. If you can carry from other states, but you have to have a permit that we recognize.
Follow up?
Senator Winder?
I think specifically what I would like of a record is that just because they're allowed to carry in Idaho doesn't give them the right to carry in other states without a carry permit, or in the case of Washington, I think they actually require an enhanced permit to carry there and recognize our license.
Yeah.
Senator McKenzie?
And Senator Lodge and Senator Winter, that's correct.
And then, if I might, just, Madam Chairman, the other thing I would like a little bit of information about, there still are additional federal restrictions that deal with carrying firearms, and I just think it's important that people realize that this isn't the end-all of the law, that there are other laws that could impact them, and that just because we give them the right to carry under our statute doesn't necessarily provide any supremacy over the federal regulations.
Senator McKenzie?
And that's correct, and as you point out, people don't always realize that. On page 5 of the bill under current code, we've got the restriction is for any other reason ineligible to own, possess, or receive a firearm under the provisions of Idaho or federal law. So for example, if there's the gun-free school zone that prohibits carry within 1,000 feet, if you are permitted under Idaho law to carry without a permit, such as an elected official, but you're within 1,000 feet of those schools, you're potentially having a federal felony. So we don't supersede that.
Okay. And then one other quick question, if I might.
Yes, Senator Winder?
Thank you, Madam Chairman. On page 7 in section 20 there, lines 26 and 27, it states, such renewal license shall be issued as an enhanced license pursuant to provisions. Does this mean someone can't get a regular concealed carry permit, or does it have to be, or does this mean that they, without the training required, they can get an enhanced permit?
Senator McKenzie?
No, Senator Lodge and Senator Winder. So what this says is this is the section that refers to those who are 18 to 21. So during that age range, if you want to get a license, you have to go through the enhanced carry procedures. If you do that, once you turn 21, you are automatically qualified to receive the enhanced license. So you just get much greater
Thank you. That makes
reciprocity. Yeah.
sense. Thank you.
Senator Winder? Okay. Are there any further questions at this time for Senator McKenzie? Seeing none, thank you, Senator
Thank you.
McKenzie.